Rosaria, io ti vedo. Io ti vedo, Rosaria.
Sì, no, sto parlando con Cassandra.
Ok, ti ho impostato come relatrice, così puoi condividere lo schermo.
Sì, perfetto. Non c'era un problema di indirizzo.
Adesso vediamo se possiamo partire ufficialmente, perché... Ok, partiamo. Okay, welcome to this session of Eunice Week, which is offered by the University of Catania. My name is Daniela Herrera. I'm the Erasmus Institutional Coordinator here at the University of Catania, and I am also a professor of international relations. We are very glad to be part of this initiative, which is the Eunice Week, and we are happy to contribute with a lecture. The lecture will be given by Professor Rosaria Sicurella. She's a professor of criminal law at the University of Catania, and she's also Deputy Rector for Institutionalization, for Internationalization in the area of social humanities and legal studies. Her lecture title is European Values, European Identity, European Culture, Reshaping Teaching and Researching in Law Faculties. I hope you will enjoy our contribution, and I give the floor to Professor Sicurella.
Thank you, Professor Herrera. Thank you, Daniela, and welcome to everybody. Actually, it's for me a real honor, to give my contribution to this, Eunice staff, Eunice Weeks 2022. And I will try to present, a lecture, to present actually an informal speech and probably a contribution, hopefully a contribution also to the debate on the, I would say, on the crucial topic of European values as the very basis of European identity, and also in my specific perspective of a lawyer, also at the very basis of our European legal culture, which is going somehow to reshape, or at least is pushing for a reshaping of researching and teaching, even in law faculty. I say even in law faculty because, as you all know, law, and especially criminal law, that is to say my area, has long been resistant to constraints coming from European integration process. I will try to support my presentation with, if I manage, with some slides. Just few seconds. I hope. That's it. I hope that you can see the slides. It's a very basic presentation. I only prepared some slides to support my presentation. It can be much easier because I will give just very few provisions. The content of few provisions, just to deal with what is the subject topic of my presentation. So how I can approach, obviously as a lawyer, I will approach the idea of European values, try to find out I would say the documents on which these European values result to be founding on. And first of all, the discourse of European values was developed by the European Court of Justice in the framework of what we can call the discourse about constitutionalization of the European Community legal order at the beginning, and then European Union later on. Indeed, since probably the end of 70s and the beginning of 80s, the jurisprudence, the European Court of Justice has started shaping the European legal order according to a constitutional approach. That is to say, a European legal order based on a shared fundamental principles. Indeed, and these are the points that I'm going to develop during my presentation, apart from this origin of the discourse, it is the rationale itself of the EU as a borderless area, so the area of freedom, security, and justice, which needs to rest on a well-grounded set of common values, which are now enshrined in Article 2 of the Treaty on European Union in the Lisbon version. According to this reading, common values had to be considered to fund a basic inherent trust among the member states. So trust will be another word that I will try to analyze, which is to be considered as a constitutional element of the EU integration, despite the lack of any express reference to trust in the treaty. In all this discourse, an essential role has been played by the protection of fundamental rights in the progressive definition of the European identity. That is to say that the protection of fundamental rights has been considered as the core of a shared culture, and especially a shared legal culture. And all this discourse will end up with some reflection, with some, I would say, more than reflection, food for thoughts about the pivotal role that university can, and in my opinion, have to play in boosting such a European identity, and also, I mean, developing European values. So first, in a way, so I will try to go through the progressive development of the constitutional dimension of the EU and the coming under of the spotlight of the European values. Then I will go through the discourse about trust and mutual trust in the EU, and then finally in the progressive development of a European legal culture and the consequences that this can have on researching and teaching in European university, and especially in law faculty. I think it's interesting, at least from a law perspective, to start with a very, I would say, basic definition of what is the European constitutionalism, on which the jurisprudence in the 70s of the European Court of Justice has been developed. European constitution, the definition, one of the most, agreed definition of European constitutionalism is the one indicating the constitutionalism, the process by which the European community has shifted from a legal order founded by international authorities, negotiated by the governments of state under international law, and giving birth to an international organization, to a community which has evolved and behaves as if its funding instrument were not a treaty governed by international law, but a constitutional charter. This is exactly the expression employed by the European Court of Justice, governed by a form of constitutional law. It is interesting to stress which was, at that time, the pragmatic interest behind this definition and behind this process. And this interest was resolving the perennial existential insecurity about the specificities of European community legal order with respect to international law. Once moved in this direction, there is a crucial, a burning issue coming out, that is the issue of legitimacy. And together, obviously, legitimacy of this new legal order cannot be found anymore in international law. So there was a first try referring to an European demos, a unique demos, a unique people, an European people, but this would contradict, I would say, European community basic ideals, which is, I mean, to find new solution instead of importing, instead of copy-pasting concept and notion which have been created in a state dimension. And here, a new concept we all know comes along concerning the citizenship of the Union. And there, this is interesting to know. Actually, there is the Article 8 of the Treaty of the Union establishing such a citizenship of the Union as something which is distinct from nationality of the member state, and the very core, the very essence, the very nature, and the very core of this citizenship of the Union in the discourse at the political level, also at the level of the European Court of Justice, is commitment to shared values of the EU. There, the discourse about shared values, I mean, comes out in order to establish, in order to found, actually, the new legitimation of the EC as a new and specific legal order with respect to international law models. I would say today we can find, I would say, the most developed drafting, wording concerning European values in Article 2 of the Treaty of the Union in the Lisbon version, and which is actually the result of a long debate started more or less with the adoption, after the adoption of the Maastricht Treaty, which actually realizes the first big radical, I would say, extension of competence of the European community, and even the introduction together, in addition to European community, of the European Union. After Maastricht, Amsterdam, the Treaty of Amsterdam, there was a great effort to strengthen legitimacy of this new dimension of the European integration process. And it is in the Maastricht Treaty that the reference to European values comes out, but it is only in Article 2 of the Treaty of the Union in the Lisbon version that we have a complete and achieved, we could say, reference to European values as values common to all the member states. Here I just put the wording of Article 2 just for your comfort, and this is extremely interesting to see that this article, following the experience that was that in the so-called European Convention was made with respect to the constitutional treaty, which then was abandoned. Article 2, so among the very first provisions of the treaty, writes this very basic statement concerning European values, concerning common values of the Union. And Article 2 says, you can read, the Union is founded on values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. We can say that in this provision, we can find a kind of summa, the synthesis of all the main principles and values that we all know pertain to the member states of the European Union. A crucial role, a primary role, we would say, in the establishment, in the discourse concerning European values, has been gained in the time by the protection of fundamental rights. We can say, according to most of the scholars, that protection of the fundamental rights was, I would say, the second motor of the European integration, together with joining somehow the market dimension. Indeed, since the 70s, the European Court of Justice has developed a very articulated discourse concerning the establishment of a European system of protection of fundamental rights. And which is interesting to stress is that even the European Court of Human Rights, the Strasbourg Court, in its jurisprudence, starting from the so-called Bosphorus jurisprudence that has been recently confirmed in the case Avotin versus Lettonia, the Strasbourg Court stated that the system of protection of fundamental rights at the EC level can be considered as offering a level of protection equivalent to what is required by the European Convention on Human Rights, something which is extremely important because there was the risk that the Strasbourg Court could assess compliance with the European Convention of national legislation implementing EC, implementing community law, and so the risk of a conflict, a risk of almost very problematic situation could arise in case that the Strasbourg Court could have concluded in the sense that national implementing legislation of European legal acts, or essentially European directives, was not in line and was not in line with the European Court of Justice, with the European Convention on Human Rights. So this jurisprudence of the Strasbourg Court somehow establishes an equilibrium, establishes a situation of overall equivalence and overall, equivalent protection of fundamental rights in all, not only the member states of the European Union, but all over in Europe, because we have to consider that the Convention on Human Rights is related to the Council of Europe and not to European Union. Indeed, the European Court of Justice, again, already at the end of the 70s, was extremely attentive to the claims coming from member states' constitutional court, especially some member states' constitutional court, primarily the German and the Italian one, of adequate protection of fundamental rights as the essential requirement to accept primacy of EC law. And because of that, the European Court of Justice, because of the lack at that time, because of the lack in the original treaties of any provision referring to protection of fundamental rights, has established this European system of protection of fundamental rights, first of all establishing through its case law a non-written catalogue which was based on constitutional traditions common to the member state and on international treaty binding the member state, and essentially the European Convention on Human Rights, and then shifting from this non-written catalogue to the first catalogue proper of the EU, the EU Charter of Fundamental Rights, that was solemnly adopted in 2000 beside the Intergovernmental Conference in Nice, but it was formally binding, was recognized as formally binding only since 2007, that is to say, the moment when it was adopted, the Treaty of Lisbon. And indeed, I would say the achievement of this development in the jurisprudence of the European Court of Justice can be considered the wording of Article 6 of the Treaty of the European Union in the Lisbon Treaty. Here we have, again, this is among the, I would say, the common provisions at the beginning of the treaty. So it's a kind of constitutional statements somehow concerning the European Union legal order. And what Article 6 says that the Union recognizes the rights, freedoms, and principles set out in the Charter of Fundamental Rights of the European Union of the 7th December 2000, as adopted then in 2007, which shall have the same legal value as the treaty. Because of this statement in paragraph 1 of Article 6, the very unclear, the very, I would say, doubtful nature of the European Charter when it was adopted in 2000, now, this is absolutely overcome because Article 6 of the Treaty of Lisbon establishes clearly the binding nature of the Charter, because the Charter has to be considered as to have the same legal value as the treaty. But what is interesting enough is that Article 6 establishes the Charter of Fundamental Rights as the primary source of fundamental rights with respect to the legal order of the European Union, but this is not the exclusive source of fundamental right. Indeed, according to paragraph 3, fundamental rights as guaranteed by the European Convention for the Protection of Human Rights and Fundamental Freedoms, and as they result from the constitutional traditions common to the member states, shall constitute general principles of the Union law. This means that even if the Charter takes the primary role in establishing fundamental rights, the system of fundamental rights in the EU, we have such a reference to the European Convention on Human Rights and also to constitutional traditions common to the member states. That is to say, the original sources of the systems of fundamental rights that are still in the provision. This is a kind of, we can consider the provision in paragraph 3 like a kind of updating clause of the set of fundamental rights in the EU. So the reason of this paragraph is try to respond to the worry about the fact that setting a precise catalog of fundamental rights could risk to limit an evolving protection of fundamental rights. In this way, the main list of the European Charter, as referred to in paragraph 1, can always be updated by possible evolutions in the case law of the Strasbourg Court and also possible evolutions in constitutional traditions common to the member state. Another, I would say, crucial element of this overall dimension, European Union dimension of protection of fundamental rights, which are, as I said before, at the very core of European values, is what Article 6 establishes in paragraph 2. That is to say, the accession of the European Union to the European Convention for the Protection of Human Rights and Fundamental Freedoms. Indeed, this would actually enshrine, would impress actually a radical, I would say, a dramatic evolution, a dramatic upgrade, would say, of the protection of fundamental rights at EU level. However, we must say that in 2000, recently, it's not really recently, we are talking about 2013, actually there was a very critical opinion of the European Court of Justice that, according to the provision in the treaty, has to be give a favorable opinion about the agreement between European Union and the Council of Europe concerning the accession of the European Union to the European Convention. And so the European Court of Justice in 2013 gave a very negative opinion about the proposal for an agreement in this sense that had been drafted. Actually, it was a very detailed and careful agreement drafted by the Commission. And for at least, it is not, thinkable. We cannot really expect in the near future a very, interesting developments concerning the accession of the European Union to the Strasbourg Convention. I think it's interesting to stress in a conversation, in a discourse concerning European values, in European identity, that these significant developments concerning European constitutionalism, and also this very interesting achievement at the level of the EU legal order concerning the establishment of European values and concerning the I would say the interesting development about the system of protection of human rights have not excluding persistent conflict between the EU and member states. But the reason of these conflicts is actually competing positions of the European Court of Justice on the one side and constitutional courts on the other side, concerning the fact to have, I would say, the last word about the adequate protection of fundamental rights, which are recognized both at European level but also at national level. In this, I would say, in this confrontation, I would say, in this conflictual confrontation between the European Court of Justice and constitutional courts, and obviously some constitutional courts, and again, the German Constitutional Court, also for some aspects, the Polish Constitutional Court, and also Italian Constitutional Court. In this confrontation, the reference, the appeal to constitutional identity by the National Constitutional Court was actually was employed as the ultimate political safeguard in the integration process. Probably many of you would have heard some years ago about what has been called the saga, the so-called Taricco saga, which showed a real tough confrontation between the European Court of Justice and the Italian Constitutional Court. However, we must say that the correct approach, and when I say the correct approach, that means the approach that should be expected, looking at both the European Union Treaty and the main provisions at the beginning of the Treaty of the European Union on the one side, and constitutional charter and constitutional, depending on the member states, the correct approach, according to these documents, is not a conflictual approach, a conflictual confrontation concerning the respect of fundamental rights, but on the contrary, a reciprocal opening of the member state towards the EU, and vice versa, the EU towards the member state. We must say that member states' constitutional identity includes a European dimension. That means openness to the EU and other member states. And this is especially visible in all those constitutions, such as the Italian one, containing what we call the European clause. So that means an express provision dealing with participation of the state, participation of Italy to the to the integration process, the European integration process. In our case, is Article 11, establishing that such a participation can, establishing that Italy affords a limitation of its own sovereignty because of the participation to the European integration process. So this from the member states side, but on the other side, EU constitutional identity includes respect of member states' identity. And this is clearly shown in the in the wording of Article 4 of the Treaty on the European Union. Again, one of the main provisions of the Treaty on the European Union. And in paragraph 2, Article 4 says, the Union shall respect the equality of the member states before the treaty, as well as their national identities inherent in their fundamental structure, political and constitutional, inclusive of regional local self-government. This principle of respect of national identity, together with the principle which is then referred to in paragraph 3 to sincere cooperation between the Union and the member state, based on full mutual respect, can be considered as at the very basis of I would say, inherent mutual trust between EU and member state, mutual trust which is inherent in a founding concept of European integration. So just come back just a second. Even if we cannot find any express reference to the concept of trust in all the main provisions that I've been analyzing, I've been presenting so far, it is clear that the idea of trust is, at the end of the day, the rationale itself of the European process, integration process. But when we go to, expressly analyze the discourse on mutual trust that we find at EU level, we have to stress a quite strange, or in a way, problematic situation. Indeed, trust is currently a crucial concept in the political and legislative discourse, and also I forgot to write my slide, and also in many of the most interesting decisions of the European Court of Justice in, I would say, at least the last 10 years. It's interesting to stress the main area where this discourse about mutual trust has been developed in a specific area, is my area somehow. That is to say, this discourse has been developed with respect to legal instruments implementing the principle of mutual recognition that has been established by the Treaty of Lisbon as the legal principle for judicial cooperation in criminal matters. The idea, which is, the main idea supporting the principle of mutual recognition, is that each member state recognizes the criminal law in force in another member state, even when the outcome would be different if its own national rules were applied. This is a kind of, I would say, rewording, is a kind of an adaptation of the principle of mutual recognition that has been developed in the market area into the legal area, which has provoked many reactions, but I will not go through this reaction in my presentation. Which is the interesting point to stress, that the Court of Justice, in the discourse of the Court of Justice, in order to support all the construction concerning the principle of mutual recognition in judicial cooperation in criminal part, the European Court of Justice, as one of the main arguments that has been used, is the necessary implication that member states have mutual trust in their criminal justice. According to the reasoning of the European Court of Justice, trust does not need to be legally established because it is to be presumed according to the present situation, the present level of European integration process. More precisely, which is the reasoning of the European Court of Justice on this point, and I go through very quickly because again we will find the reference once again to European values. The reasoning is that trust is at the very basis of the EU as an ever closer union among the peoples of Europe, which is established in Article 1 of the Treaty on European Union. Trust rests essentially on the fact that all the member states share the same common values. Again, the reference to these common values in order to legitimate new, I would say, new developments of the European integration process. Fundamental premise, the fact that member states share the values in Article 2 at the same time implies and justifies mutual confidence. So the position of the European Court of Justice is in the sense of a presumed mutual trust, even though we can, remark a quite recent shift of the European Court of Justice in, the last jurisprudence, above all concerning, European arrest warrant, departing from normative concept of mutual trust. Which are the criticalities of this presumption of mutual trust? The criticality, first of all, relies on the fact that the compliance in abstract with common standards, which are essentially established also through harmonizing directives, harmonizing European legal documents in the field of cooperation in criminal matters, is not sufficient, since trust in concreto requires a true equivalence of protection together with the mutual knowledge of the same, which is obviously not easy to achieve. This means that fostering mutual trust requires that it is not approached exclusively as a legal concept, but rather as a notion resting also on an inherent subjective dimension. This means that, at the opposite of what has been for a long time the position of the European Court of Justice, mutual trust cannot be pursued and achieved through legal measures alone. And here comes, in my opinion, the crucial role that should be played and has to be played by university in this process of trust building. And the reason is that actually, when talking about trust, we cannot only limit this discourse to trust among legal practitioners, or even trust, between member states, as it is in the discourse of the European Court of Justice, but more generally, the process of trust building has to focus on trust of individual citizens faced with the prospect and the very content of European integration. I don't see my slides anymore here. Sorry, just a second. Okay. Obviously, a crucial role in this process of trust building is to be played by, and this is obviously the reason why I put also as the very contest subject matter of my presentation, the issue of reshaping, researching and teaching in law faculty. Obviously, a crucial topic is trust building of all legal professionals of legal professions, and indeed, enhancing mutual trust among legal professions requires a more substantial understanding of mutual trust based on the idea of developing a shared legal culture while maintaining, at least in part, diversity in national law. So, after talking about European values as the very core of European identity, then we come to afford the question of developing a European legal culture, which actually rests on shared, we rest on, on a more substantial understanding of mutual trust, which again rests on European legal values. And the developing of a shared legal culture actually implies a twofold challenge. First of all, the need for a shared legal culture rests on the necessity to boost awareness of other member states' legal systems and also of existing commonalities, and thereby enhancing mutual understanding. Actually, when we focus about the need about boosting awareness of other member states' legal system, this implies a radical change in the, I would say, tradition, in the classical approach to the teaching of law, focusing or at least primarily addressing specificities, detailed detailed and specific solutions of a single legal system. This approach makes it more difficult than to, I would say, to boost the openness to others member state, to other solution in other legal system. On the contrary, developing a shared legal culture would need to rest on the, I would say, primary focus to be given to existing commonalities among the different legal systems, existing commonalities that can flow either from, I would say, common tradition, common legal tradition, or flow from the implementation of European legal standards. This is the first, crucial point to develop a shared legal culture. The second crucial point is the need, when thinking about developing a shared legal culture, is the need of a complete rethinking of the teaching and researching law faculties, which flows from the fact that the integration process has radically transformed the legal framework in which any lawyer is called to act. This means that actually any legal order of any member states of the European Union is nowadays a much more complex reality, a much more complex structure than in the past, because this is actually the point of conjunction, the point of interaction of different dynamics flowing from interaction between different legal orders and obviously interaction with dynamics of the European integration process. This means that in order to, this means that in order to fully understand, in order to be capable somehow to really manage his own legal order, any legal professional has to know and has to be able to manage all these dynamics, because they are dynamic also of the internal legal order. Today is not possible to think about a lawyer, even a criminal lawyer, and I wish to stress this because criminal law has long been considered as the point of resistance with respect to the European process, because of the fact to be the highest representation of sovereignty of the state. But this is not the case. This is not the case anymore. If this is the situation, and this is the present situation now, also for law faculties, an existential question arises about the selection of the most adequate contents and methods for the education and training of the what I call the modern lawyer. It is true that I think that, I don't know if in the audience I have colleagues teaching in law faculty. It is true, but I think this is also a situation that can be experienced also by colleagues in other faculties. It is true that we are confronted with students which are much more aware than in the past. I can consider also a situation looking at my generation. Today, students are essentially, I would say mostly, are much more aware of the European dimension that we live in, and also in law faculty. Somehow the students are, feel to be part, feel that this European dimension is part of I would say their learning needs. And for sure, one of the causes, I would say, one of the causes of this situation is the fact that, unlikely what happened in the past, I would say European current affairs, European news are, continuously, hopefully, are continuously in the media, are now become part of our daily news. However, I think it is essentially up to us to boost this European attitude of the students, probably would say also the most brilliant or enthusiastic student, how providing the necessary tools to understand the present legal framework. And among the many I would say possibilities, I can think about, first of all, developing principle-based teaching, and also stimulating students' capacities to approach legal documents of various nature and source. So it means legal documents, national legal documents, European jurisprudence, other kind of legal documents, and again, and moreover, stimulating also interdisciplinary and comparative research projects aiming at proposing common understanding and common legal solutions. This is not absolutely an easy task. On the contrary, it's a quite challenging task. Because, and I was just stressing it, all these changes, these radical changes are not at zero cost. I think we are all confronted to the issue of, I would say, teaching material, with the issue of the number of hours of our teaching, the issue of credits that are granted to a certain teaching. Obviously, when I decide to replace replace the traditional approach in teaching, in my case, criminal law, with a different type of teaching, a principle-based teaching, which allows me to make reference to European case law concerning, for example, very fundamental principle of criminal law: legality principle, harm principle, fault principles, the function of punishment, which are topics with respect to which now we have a quite extensive case law essentially from the European Court in Strasbourg. When I develop such a teaching that, in my opinion, enrich necessarily I would say the content of my teaching, obviously, I am in a position I'm obliged somehow to cut out from my teaching some other subject topic, theoretical constructions, arguments, jurisprudence, that so far have been the very basis, have been the very contents of a classical approach to the teaching of law, and especially of criminal law. And again, the fact to boost, the fact to help, to support the capacity of students to approach and to work with legal documents of various natures, so not only national law, not only jurisprudence of the National Supreme Court, of the National Constitutional Court, but also jurisprudence of the European Court, which is not just a matter of, I would say, knowledge, general knowledge of other jurisprudence, because the jurisprudence, the case law of the European courts has an impact, is in different ways binding also national legislature and national courts. So learning about European jurisprudence is a component, an ineliminable component of a full learning, of a full knowledge about dynamics in our own legal system. Again, stimulating an interdisciplinary and comparative approach in teaching and also in research project, again, is, I would say, time consuming. So again, this choice puts me, I would say, in front of the need to select the topics, and so to change, to select, let's say, the contents of my teaching according to different criteria with respect to what was in the past. But I think that this, I strongly believe that this is a path that should be done, because our responsibility as a professor, and I would say our responsibility as academics, is to, I would say, to fight, is to engage in providing content and methods of teaching, or providing support for, for researching, in a way that we help, we boost, we prepare our student, we prepare our PhD students also, we help our young researcher to be not only, I would say, not only to fully understand the legal context where they are supposed to, to work, but also in a way that we prepare those people to also somehow be able to assume a leading role in the progressing development of a European legal culture. And I think also that in this perspective, internationalization programs involving not only students, PhD student, but also researcher, also professor, stimulates a fruitful confrontation of teaching models and also a fruitful confrontation concerning the organization of teaching materials. I think just I want to fast. This I think something which is extremely challenging, especially for Italian university, and obviously I'm referring above all about law faculties. All what have been said in this last concerning developing, presenting these last 2 or 3 slides, put also under the spotlight a very sensitive question for law students in Italy, which is also the sensitive question concerning the knowledge and appropriate and adequate knowledge of foreign languages. First of all, English, the English language, because it's also in law fact, also in law fields. English has become the primary communication language. So this is a necessary tool in this perspective of a modern European lawyer that not only can be fully aware, has to be fully aware of what happens in its own legal order, but also should be also able to actually work outside the national borders, because we have also to keep in mind that when I talk about teaching in law faculties, I'm not referring anymore exclusively to, we'd say, the classical legal professions, such the ones, the judge, to be judge or prosecutor or defense lawyers, or even the notary. But obviously also the identity of the lawyer has been changed. We have new legal professions that, that the legal profession in the inside the borders of national of Italy, but above all outside. We can think about all the, I would say, all the legal professionals that are employed in international institutions, or for example, our degree students that now work, our degree that now work in foreign university. Which is this? I want just to put some elements that are not I put there that I this is a conclusion, but actually more than a conclusion, this should be considered as like food for thought. I think that, again, I wish to stress the role of the universities, because we are experiencing a very, I would say, a very critical moment when referring to the European values and the, I would say, and the European integration process, because we all know, and also, the news of the last days has shown again, if this was necessary, that now there is a strong discourse in the last years going on about the need to go back to nation states, back to national identity, back to national sovereignty and national borders, and obviously also to national people that should be at the very center of any kind of action by state authorities and also European authorities, in the perspective that see the national people and the, I would say, the advantage or the development of the national people as in, I would say, in conflict with the advantage or the development of the an European action, I would say, a European action. But we all know that this is, I would say, this kind of argument is in large part unrealistic and also anachronistic. And because I think that I would say the globalization process we have been experiencing in the last decades is something that cannot be stopped anymore. So the thing we have to think about is that we have to be prepared to not to passively, I would say, suffer the consequences of such a globalization process, but try to have the tools to manage this globalization process. And again, universities, that should be plural, but must play a pivotal role in the process of trust building in all areas. Trust building that means I would say a perspective which is absolutely at the opposite of the perspectives I indicated at the very beginning of this slide, so of this discourse of back to the nation state. Because universities somehow have the responsibility of improving the subjective dimension of mutual trust. And when I speak about mutual subjective dimension of mutual trust, this means, and this is the reason why I think that this is not only obviously the responsibility of law faculties, but responsibility of universities in any area. Because when we talk about improving mutual trust, is not just a question of improving mutual trust among member state authorities, nor even among legal professionals in general, but what has to be boosted, what has to be improved is trust of any individual citizens faced with the prospect of European integration. And I think that in this perspective, university can show that they do not simply support European values, but they live those values. And I think that this should be, we always have to, I mean, any of us, I mean, in our role as an academic, as a part of academic institutions, etc., we must have also this in mind, the fact that in the way we conceive our role in the university, we should try to we should try to engage in a way that is a concrete, I would say, a concrete enactment of the European values that we all share, that are for a long time have been written in the paper, written and probably also stated by European and national courts, but that can, I mean, very often faced obstacles when the question is to really live those values and really enact those values. I think I can stop here because I don't want too much, I mean, burden you. And so I thank for your attention. And obviously, I'm absolutely ready to and happy to discuss and to answer to your question, if any. Thank you.
Thank you very much, Professor Sicurella. Rosaria, thank you so much. It was a great lecture, and I think we have learned a lot from your expertise. Just to remind that we were live on the Eunice YouTube channel, so we have checked that there were several users connected and listening to you, and we have also asked whether there were any questions or comments that can be typed in the chat, and we will be ready to read online, and you can reply and give your feedbacks online. So far, I think we have no interactions. Just let's wait, if you agree, just a couple of minutes just to see if there are burning questions or comments now that the lecture is ended. Otherwise, we can close, and just also reminding the Eunice audience that the recording is always available, and it's possible to listen to your fantastic lecture again. Actually, we don't see any comment so far. Yeah, so we've just given last couple of minutes. So I would like to thank you, Rosaria, once again for giving this fantastic lecture, and also thank all the people that have listened to you and interacted and joined the contribution on the part of University of Catania to the Eunice Weeks. And just to remind that we are very happy to be part of Eunice, and we will continue to feed the Eunice family and being part of the Eunice family. Thank you so much. Bye-bye.
Thank you, Daniela, and thank you to all, in the audience. Again, I'm very happy to be part of, to have contributed to the Eunice Week 2022. Thank you so much.